Hey, good morning, everyone. It's Trooper Bob with the ABC News 4 inside the traffic tracker with a special guest, LawyerLisa. Thank you so much for joining us this morning. Got some good stuff to talk about. You specialize in elder law, right?
Yes, elder law and estate planning.
Well, that's what we're here to talk about. Let's get to the first question here. What should someone do? Should someone do a will or a trust, or is there any difference in between it?
So a will is going to take you down one of two paths. If you have assets that are going to pass through a will, it's similar to it passing without a will. They both have to go through the probate court process, which in South Carolina takes about a year. And it means filing all of this, and it's public record, and there's certain forms that have to be filled out. There's certain notices that need to go out. And, frankly, it's just some legislative, stuff that has to be done. And if you have a trust, you can avoid a lot of that. So you don't have to file anything with the probate court. You can name who you want to be making distributions, who you want to receive distributions, and what you say goes. And it can a lot of times be distributed a lot faster as well. So a will is going to go down the same probate court process as not having a will, and a trust is going to go down the other side, which is, where you just make up the rules yourself.
When should you have a will and a trust? Should you start when you're 18? Should you do it when you're older? How does that work?
So when you turn 18, there's some basic documents that you should get. So if you've got kids in college or, anyone that's kind of, just getting started, there's some basic documents they should have. And the most important of those is even just a basic financial power of attorney. They should also get a healthcare power of attorney and probably a simple will if they have some assets that are just in their name. But that's a kind of a simple thing to have as you're getting started. And then as you get a little bit older, let's say you get married, you have kids, now you're going to have some, the next level of a will, healthcare directives, a financial power of attorney, so that if something happens to you, your kids are protected. It should have some sort of family trust built into that if you have minor children, anyone under 18. And it's going to help kind of make sure that just in case something happens, that you've got a plan in place. Then when you get a little bit older, let's say you start getting some assets, you've got, you own stuff, you have a retirement, you have a house, you have vehicles, you have some money, maybe you have started a business. Now you're going to be at kind of the next level on the pyramid, and you're going to probably want some revocable trust planning. You can do things a little more sophisticated at that level. Then you've got the kind of retirement age where you're going to look at your stuff again, and now your documents need to be a little more sophisticated because you might be aging, and so you might want to have a financial power of attorney that gives you care options to it. And then as you get older, if you do get in the place where you start having health problems, you have dementia, that those documents are all built out so that you can have a plan in place for health concerns as you age, care needs that you might have. So it's always kind of like a pyramid that's building out, and the more that you have in place before you need it gives you more options for the next stage.
Well, look, I'm getting schooled here because this is all new to me. I'm sure it's interesting to you, everyone watching. Is this, everything you talked about, is that estate planning or is that something different?
Okay, so the estate planning is more of like the get some documents, like get a will, get a financial power of attorney, get a healthcare power of attorney, and that's really for everybody. So anyone at any stage can use estate planning. But as you start thinking about, hey, I'm going to grow old, which, a lot of us hope to grow old, then you're really talking about elder law, which is not just concerned about you dying and where your stuff goes when you die, but it's more concerned about how are we going to manage how you're going to be taken care of as you age. What if you do have a mental or physical decline where you can't care for yourself? What does that look like? How do we set things in place now so that there's a plan for what's going to happen, how you're cared for, how that's paid for, who you want to do things? Do they know how to access your information to be able to make good decisions for you? So it's really important to think about elder law as you start getting, I used to say retirement age, I used to say 65 or 70, but, unfortunately there's a lot of people that do have things happen to them sooner than 65. I mean, we probably all know somebody that got really sick before that age. So, that's a rule of thumb, but, it's probably better to plan a little earlier than that.
Earlier we were talking, everyone hopes to get old and then get sick or, pass away. That's what you plan in life. But sometimes you might have a stroke early. You might, you won't be 100%. As far as medical purposes, when should you plan for that, or what should you have in place for that?
Yeah, so for healthcare decision making, there's a healthcare power of attorney, and if you're a South Carolina resident, you can get a healthcare power of attorney pretty easily. The hospitals have them; they're online. The worry with that is that you don't execute it correctly, so make sure you do that correctly. But everybody should have that. Anyone over the age 18 should have a healthcare directive. A living will is for people that are sure that they don't want certain end of life things. Hey, I'm at my end of days. I'm not communicating. I can't eat or drink on my own. I don't want tube feeding. So you might use a living will for something like that. HIPAA authorizations are a good standalone document to have, and they really can be utilized for, not everybody's going to always go to the same doctor that they sign that HIPAA authorization at for their yearly visit. You might need to go to a specialist. You might need to go somewhere else, and they don't have a form on file for you. This is kind of a master HIPAA that you can do for healthcare documents. And then, for people that are very sick, a lot of times if you're in a nursing home or you're being transported to a hospital from a nursing home, you're going to have something called a DNR, which is a do not resuscitate. And that is actually a medical document. That's not something you get from your lawyer. That's actually something you do with your doctor. And so you don't really do those until usually really, you're really sick at that point that you're doing that. But the other documents are legal documents that you do when you do your estate planning.
As far as leaving something for someone, for example, just for the sake of argument, let's say I leave a family member a car, or I leave a family member a house. Do they have to pay taxes on that?
That's a great question. So we're going to assume that you don't have a taxable estate, which right now it'd be over $28 million for a married couple.
No, working people.
We're going to working people, yeah. So for the rest of us that don't have loads of money, and that's what I'm going to talk about, there is not going to be any sort of tax when you leave stuff to your family members if you're leaving it through a will or a trust. And again, the will is going to go through the probate process. The trust can bypass it. So I have a preference that I like a trust. But either one of those, you're still not going to owe taxes on it when you leave it. So a car, a house. Now it also gets something called a step up in basis for tax purposes. So if you bought your house and it was $200,000 when you bought it, and when you die, it's worth $600,000. I don't even think you can have a house for $600,000 here now. But for $600,000, that $400,000 of gain that would normally be there that you would have to pay taxes on, say it wasn't your primary residence and you were just selling it, you would owe tax on it. But if you die, your heirs or your devotees will take it at the $600,000 value. So they're not going to owe any capital gains tax on it. So it's a really good incentive to do your planning properly with an attorney that specializes in this to make sure you're taking advantage of some of the tax benefits that there are. Now, if you have a retirement account, like let's say you have a 401k or an IRA, and you put your money in there pre-tax, or you had an employer match on something and they put money in, that's all going to be pre-tax. Now, if you have a Roth IRA, that's different. You've already paid the taxes on it. But a lot of people have some retirement savings. If you haven't paid the taxes on it, somebody's got to pay the taxes on it. So if you live long enough that you start taking distributions, and they call that RMDs, or required minimum distributions, then there's going to be taxes paid when you get those distributions as you get older. But if you die and there's still money in there, whoever you pass that to, when they take their distributions, they'll pay tax on it. And the other thing to keep in mind is there's a lot of tax strategy that can be done with estate planning. So if you do have a retirement account, one of the things that we do is we can look at, when are you taking these distributions? Is somebody sick? How successful are your children? Because your children might be at a really high tax bracket and you might be at a really low tax bracket. And some of your planning might be to take a little more out of your IRA, pay the tax at your lower rate, invest it, let it grow, and now the taxes were already paid on that money. And so when you pass away, your family can inherit it, and they're not going to owe all those mandatory taxes on it.
Well, good information here, that's for sure. Let's switch to beneficiaries. Can you name more than one person as a beneficiary, or is it best to just have one or several?
Yeah. So I feel really strongly about beneficiaries. They should be whoever you really feel in your heart that you should leave stuff to. So if you have a cause that you want to name as a beneficiary or part of a beneficiary, you've got children, you've got a spouse, you've got a niece or a nephew, whoever it is that you want to leave stuff, you got a best friend that's struggling, you know, if something happened to you, you want to leave her something, you know, you should name who you think is best, and it is totally a personal choice. And so whatever that is, whoever that is, if it's an organization or people, you name who you want to name. And then the plan can be developed around who you want to leave stuff to. So I'm going to do your plan a little bit different if you're leaving everything to an animal organization that's a nonprofit than if you're leaving everything to your 2 kids. Because there's different tax consequences to that, and also different strategies and logistics for how that stuff is going to get to its ultimate destination. So we can develop a plan around what you want.
All right, let's switch to leaving, having someone, a fiduciary or a trustee in charge of your stuff. What's the difference? And how many people should you do? Should that just be one person that you trust?
Yeah. Okay, so I also think that it is best to have one person be your agent or your fiduciary. And that's because, you know, think about it, you know, you got 2 people, we could have a disagreement about something, or I could think you're doing something and so I'm not doing it. You know, there's just a lot of things that happen in these limited roles that it can cause issues. And so from my experience in doing this, and I've not only done planning, but I've also done a lot of litigation over the years. I've seen where people have dropped the ball on stuff or gotten in fights about it. I do feel strongly that you should name one person, and then you should have backups. So I always like naming at least 3 people to take care of your stuff. You know, so you'd have that one person and then the 2 backups to them for whenever you might need it. And then again, that covers if something happens to one of them, that you still have options. Unfortunately, I have definitely seen situations where for example, a husband names a wife names a husband, and then, you know, the husband gets really sick and the wife passes away, and now he's got nobody. And he needs an agent, and now we're going to court and we got to file for a conservatorship, and we got to go through all this. There's a lot of stuff you have to do to get a conservatorship, and it takes some time. So you can't just quickly get access to their funds to pay their bills. You're waiting, and now somebody's got the burden of filing a court action, paying for that court action, and then paying their bills in the meantime to take care of stuff. That's a lot on your family. So having the right agents in place is a really good way to protect your family and make sure your stuff is taken care of.
All right, regarding the will and the trust, somebody passes away, they have a will and a trust, do the family members still have to go to probate after that?
So if they do a will, any asset that's going to pass under that will, so, you know, a lot of people say, oh, I've got a will and I'm going to have my stuff go through the will. Anything that is in your name that doesn't have a beneficiary designation will go through your will. Now, if you've got a joint account with somebody else, that goes directly to whoever the survivors are on your joint account. And if you have something with a beneficiary on it, like a lot of people have a retirement account, and the retirement account has beneficiaries on it, it'll go to those beneficiaries. But, you know, if let's say this tracker was in your name and you passed away, that's going to go through your will. Now, if you said, I don't want stuff going to court, I kind of want to simplify the process for my family, you can put whatever your asset is into your trust, and then when it's in your trust, it will be administered through your trust. So that wouldn't have to go to court. So anything passing through your will goes through the court process. Anything that bypasses that process would be like a beneficiary designation, a joint account, or anything that's owned in your trust, because that can just go directly to the beneficiaries.
I had a family member pass away that had a will and everything was smooth going, but I've heard people that had family members pass away, brothers and sisters without a will, and there's 4 other brothers and they're fighting over everything, and so you definitely don't want to muddy up those waters. You want everything ironed out. Now, if you go to a store, I want to call them, let's say Staples, they sell wills and stuff. Should you go type up a will from that, or go see an attorney and get one done?
Well, you can probably imagine what the answer to going and getting a will at Staples is, or one of these online companies. And so I have an example of what I'd like to compare that to.
Sure.
So it's the equivalent of walking into a shoe store and walking up to the lady that's working at the counter and saying, I need a size 8 shoe. And the lady walks in the back room and she comes out with a box of shoes for you, and she goes, with my shoes, you're probably not a size 8 shoe.
Oh,
but,
it ain't narrow.
So you get the size 8 shoe and you go, great, all right, and I buy them and I take them out and I open the box, I put them on, and they're tennis shoes. Okay. Well, but I'm going to the gala tonight, so
Right.
tennis shoes aren't really going to work for me at the gala. Or, I'm going mountain hiking and you gave me high heels. Probably not you high heels, but, Or I'm going to the beach and I need flip-flops.
Sure.
So, or it's snowing and I need boots. Like, I got the size 8 shoes that I asked for, right? And that's the equivalent of going online and getting what you asked for. I want a will. Well, a will isn't what's best for everybody. And a will plan isn't what's best for everybody. But when you go online or you go to Staples or something like that and get these documents, you're asking for a document and they're giving you what you asked for. They're not giving you what you need. And that's the difference in going to an elder law attorney who's going to plan this out for you. Is an elder law attorney is going to say, let's figure out what you need.
Sure.
Not what you think you want, because you probably aren't an expert in this. You probably aren't really sure. You've heard you
So
need
you don't
a
know
will.
your options.
You don't know what all the
Right.
options are. And a lot of times, and we do a lot of education around this, a lot of times people come to one of our seminars and they learn about what a trust does and they go, I want a trust. But if you walk into the store and you're picking out something off the shelf,
Sure.
they're not going to offer, that's not even going to be on the agenda. So you're not going to be able to get what you really need.
That was excellent. As far as one more thing about a will, I will someone, let's say, a car. Does everything that need to be willed put in the will? Like I will a family member a picture in my house. Do I will another one my lawnmower, my riding lawnmower that's brand new? Do you have to itemize everything, or what do you think about that?
Yeah, so, all right, for example, if I've got one kid and I'm leaving everything I own to my one kid and that's where I want everything to go, you don't need to worry about doing a personal property memoranda because everything's going under your will. And whether you did a will and it's going to go through the court process or you have a trust and it's going to avoid all that, again, that would be my preference, it's still going to go where you want it to go. But if you've got multiple people that you want to have your stuff, or if you're leaving stuff to a charity, but you got personal property, the church doesn't want your riding lawnmower, maybe, but they probably don't want your shoes or your clothes or some of your other stuff. So if you've got somebody you want to leave personal property to, a personal property memoranda to go with your will or your trust is really a great option. And so think about it this way, if you've got 5 kids, I got 5 kids. And so if I said, I want, Tyler to have this, I want Jacob to have this, I want Jackson to have this, I want Jensen to have this, I want Juliana to have this, and something happens to me, somebody's going to go, hey, Juliana, your mom wanted you to have her wedding band.
More personable.
And it's like a gift
It's
then.
a gift, right.
Versus, we'll assume they were all adults at the time, them walking into my jewelry bin or my closet or my house and picking through stuff and kind of maybe fighting over stuff.
Sure.
I can't imagine 5 kids not fighting over something, right? But if you don't list important things out, it's just they're having to kind of grab at stuff.
Right.
And it's a whole different feeling than if your mom says, hey, I want you to have this ring from, from me being married to your dad for however many years,
Sure.
We'll assume he dies first, right? But, it's just a different feeling. And then here's the other part of it is that if you've got certain valuable things, you can kind of divvy those up the way you think is appropriate. Because, things that are more valuable, your diamond ring is going to be different than, your socks in your sock drawer. And so if you can list out things that are important or valuable or sentimental in your family,
Sure.
that's going to go across a lot better to whoever you're leaving it to, whether it's your kids or other family members, or even if you're leaving stuff to charity. Just really listing that out is important.
Well, like you said, it's a tough time. Somebody passed away, but it's more personable when it's written out to you because that person definitely wanted you to have that. That item.
Well, and I want to add something to that. This is the last memory that your family will really have of an interaction with you. And I think we've kind of forget that that's going to be the last thing that you did for them or did to them. And so I have a lot of families that come in and they're hugging our team and they're going, you know, thank you so much for setting my parents up with the trust. This was so easy. Everything kind of flowed and went, you know, the way it should go, the way they knew their parents wanted it to go. And that is the feeling that they have, that last kind of remaining memory and feeling of them. Because this is dealt with after the funeral. I mean, this is the last thing that they deal with. Versus families that get involved in sometimes litigation that didn't need to be, or just family quarrels that didn't need to be, or resentment is usually where this ends up. You know, not everybody goes to court over it, but you might not talk to your brother again because of how he acted or how his wife acted, you know, when you guys were divvying stuff up. And a lot of this can be dealt with, and you can kind of leave this lasting impression on people.
A lot of times you hear, well, they wouldn't want that, or they wouldn't want this. Well, now it's spelled out.
Yes.
So you know exactly what they want, what they don't want.
Yes, there's so many things, and we have these things, we call it a go binder, and we do prevention planning. It's got a cute little ducky, rubber ducky with it. You know, it's like it's not a morbid thing. It's a planning ahead, being proactive, just like you might do a budget for your family, or you might make plans for your vacation. It's making sure your stuff is organized in a way that everyone will know where to get information, what you wanted, and they'll have some legal directives on why they should follow it, how to follow it, and what you really want. And you can spell all this stuff out proactively. We call it getting your ducks in a row, and I think everybody should do that.
LawyerLisa, a lot of good information this morning. My gosh, thank you so much for taking time out here inside the traffic tracker to talk to us. I know the listeners and the viewers, they appreciate it. How can people get in touch with you?
The best way is just go on our website. It's LawyerLisa.com. LawyerLisa, all one word. That's the name of our law firm. We also have a LawyerLisa Charleston Facebook page. Our office is in Mount Pleasant, but we serve the whole Charleston area. And we have offices throughout the entire state. So if you've got a family member that lives in the upstate or down in Bluffton, we've got offices there. We can assist them. But LawyerLisa.com, we have lots of great information. We've got YouTube channels. We're on all the social media, so you can follow us and gain some information so that you can be empowered in making these decisions. Maybe you heard us talking. Maybe you're not sure if you need a will or a trust. You know, come and check out our information. We're trying to educate everyone so that they can make good decisions for themselves and their families. And again, LawyerLisa.com.
As always, make sure you buckle up. Don't be ejected from life. Make it a good day. Thank you for watching.
Thank you.